whereby the respondents' nomination papers were ordered to be accepted and the returning officer was directed to include his name, Fazal Mahmood, in the list of eligible candidates is dismissed. Civil Appeal number 880/2015, which has impugned the judgment of the Election Tribunal, Multan, Punjab, dated 21st August 2015, whereby the election of the appellant, Chaudhry Mohammad Arif Hussain, as returned candidate in respect of general elections held on 11 May 2013 was declared as void, and the Election Commission of Pakistan was directed to hold fresh elections which were held, and the term of the said assemblies has expired, is disposed of as having become infructuous. Civil Appeal number 1946/2023, which has impugned the order of the High Court of Sindh dated 19 October 2023, passed in Constitution Petition number 1082 of 2023, whereby the appellant's prayer for declaring him to be eligible to contest the upcoming elections was disposed of with the observation that the same would be decided at the appropriate stage if his nomination papers were rejected, is disposed of in view of the above declarations. And civil petition for leave to appeal number 2680/2023 is converted into an appeal and allowed to the extent of the appellant's disqualifications to contest elections on the grounds stated in the impugned order of the Lahore High Court dated 4th May 2023, passed in writ petition number 27043/2023, which to that extent is set aside. Learned Sayyid Ali Imran, the Secretary of the Supreme Court Bar Association, stated that the Supreme Court Bar Association sought to withdraw Civil Miscellaneous Appeal number 22 of 2022 and Constitution petition filed in 2022, which was under objection and not numbered. Therefore, the said appeal and petition are dismissed as withdrawn. Civil Appeals number 981 and 985/2018, Civil Miscellaneous Appeal number 135/2022 in civil CP number nil of 2022 and Constitution petition number 40 of 2022 are delisted, which shall be posted for hearing separately before appropriate benches. And now I'll read the order of Justice, Mr. Justice Yahya Afridi. With profound respect, I disagree for reasons to be followed. The extent of lack of qualification of a member of the Parliament as envisaged under Article 62(1)(f) of the Constitution of the Islamic Republic of Pakistan 1973 is neither lifelong nor permanent, and the same shall remain effective only during the period the declaration so made by a court of law remains in force. Therefore, the conclusion so drawn by this court in Samiullah Baloch versus Abdul Karim Nosharwani is legally valid, hence affirmed. So this we are announcing today. Date is 8 January. I am grateful to my colleagues and to yourself and to the learned amicus who at very short notice provided invaluable assistance to this court. Thank you, everyone. And please upload this on the website. So, correction. Okay.
In jurisprudence, at times your lordships have refused to answer a question when your lordships have found that to be too vague.
And that would not be a refusal to answer the question.
Yes.
That would be inability to answer a question.
Yes.
So you consider the question, you may ask me a question which I don't know. I mean, how many stars are there in the galaxy, for instance? And I'll say, I don't know, but I have answered the question by saying, I don't know. So So that's not an, so it's, we are obliged to answer a question. We can come to the conclusion and say, we don't know. Okay.
Could we also say that it says that we have to form an opinion on the question, and we could say that it's not a question.
My Lord, sorry.
So we could, I mean, it says that report its opinion on the question to the President.
Yes, my Lord.
So the question of law that's posed before us, we have to give an opinion. So one opinion could be that this is not a question of law.
That can be, my Lord. Your Lordship may say it is too vague for us to answer. It is not a question of law.
It would still constitute an opinion.
Your Lordship can, even if your Lordship comes to the conclusion.
But that response would also be an opinion.
That's an opinion.
Yes. And if your Lordship comes to the question.
We have to respond.
That a question is not properly phrased, but the meaning is apparent to your Lordships. Your Lordships can rephrase or reformulate the question.
Which we have done.
Yes.
As we have to form an advice for the President.
My Lord, this is in the nature of an advisory opinion, but according to your Lordship's jurisprudence and jurisprudence from other courts, this is binding. It virtually stands in the same rank as a judgment of this honorable court. So such an advisory opinion would be binding on all concerned.
On question of